So let's continue with the first topic under theme one. And in the first topic under theme one, we should be looking at understanding Article 368, its basic structure, and figuring out what is it that we need to really study from here. So we understand that the kind of questions that we get here are largely descriptive in terms of what is the nature of Article 368, and second, the implications of those developments under Article 368. And the best way to answer questions here would be using a subdivision method. And you must understand this extremely clearly that no doubt you have to be innovative and original in your mains answers, but innovation and originality should not come at the cost of not writing what is expected out of you, which is why one must always follow the 80-20 principle, wherein 80% of your answer should essentially be what is expected, and 20% should reflect, say, depth and should reflect an innovative argument or something that most answers in your competition may not have. So always maintain this. And now let us essentially start with Article 368 and see exactly what is it. And when we do 368, we do basic structure and we do the implications of it together. So in your introductions, what are you going to write about Article 368? First things first, you will first explain how Article 368 gives what is called constituent power to the parliament. Constituent power is the power to amend the constitution. Now, of course, there have been multiple judgments which have had multiple views on it, but as of today, can constituent power means the power of the parliament to amend the constitution, which is what you will explain in the first line. Second, if the question specifically asks you, run us through the legislative procedure of how amendments can be made, you can actually make a flowchart out of it and mention certain key points of it. For example, it can only be introduced in central legislatures, which is the Lok Sabha and the Rajya Sabha. And there are essentially two kinds of amendments under 368, one which requires state ratification and one that don't require state ratification. What is common to both of this is the majority which is used in the central legislatures, which is the parliament. And that majority is two-thirds of present and voting in such a way that it is more than total strength of the houses, right? In cases which it requires a state ratification, you would essentially look at more than half of the total number of legislatures. And these legislatures also include union territories with legislatures. This is something most students often miss out, but it is true. Even constitutional amendments which require state ratification will also be sent to Delhi, Pondicherry, and now most recently J&K, because these also have legislatures, which is a reflection of public will. And these legislatures must pass the same amendment with a simple majority. Now, all of this essentially is an indication of the unitary form of federalism. How? One, the fact that constitutional amendments can only be introduced in the central legislatures. Two, the central legislatures require a tougher majority, whereas the state legislatures would require a relatively simpler majority in the form of a simple majority to actually pass the same amendments. And at the same time, these amendments cannot be returned or rejected by the president. They have to necessarily be assented to by the president, because if the president had certain superseding powers, India would then be slowly towards the presidential form of democracy and not a parliamentary form, because the constituent power remains with the parliament. So, this is if the question asks you certain indications. So features become your 80% and implications on federalism becomes your 20%. Now, you may also want to mention a few examples of how this is used or can be used. For example, if you're making changes to the way the president is elected, you're making changes to the legislative and the executive powers of the union and the states, and if you're making fundamental changes to the appointment and removal of the judiciary. Now, some standard examples here would be, say, for example, when we talk about constitutional amendments that require state ratification, you can mention the National Judicial Appointments Commission, which was the 99th constitutional amendment, which required state ratification. GST, which was the 100th constitutional amendment, 101st, sorry, constitutional amendment, which again required state ratification, and for that matter, even the 100th constitutional amendment, which is the land boundary agreement, which is actually a combination of multiple disputes. And one of it, which essentially was when you are ceding territory, and ceding also requires an amendment, but this amendment is under 368 but without state ratification. So, this will be an example here itself. Apart from this, right to education, which is your 86th amendment, or most other amendments to the constitution happen to be without state ratification. So 99th and 101st can be your amendments with state ratification, and say 86th and 100 could be your amendments without state ratification as your standard examples to substantiate what is Article 368 if the question specifically asks you so. If the question doesn't, if the question is just asking you, say, examine Parliament's limiting power, so your introduction should just be 2 or 3 lines which says Article 368 confers constituent powers to amend the constitution to the Parliament and requires either legislature's ratification or not, depending on what is mentioned in 368. Few examples are so and so, so and so, and so and so. But I would not want you to get into writing all of these points in the introduction, because then your introduction would be unnecessarily lengthy. So this is your introduction. Now, a fundamental question that most people don't get right is, how has Article 368 evolved over time? While 90% of the students write about how amendments to fundamental rights have had an impact on 368, actually, it is amendments to fundamental rights and the relationship between fundamental rights and directive principles which have had an impact on 368. Why? Because if you can change a fundamental right, that means you can change anything in the constitution, so it has an impact on 368. Secondly, if you can implement a directive principle and override a fundamental right, you're also impacting the constitution, which is why it impacts 368. So you must mention both of these things, and I've given you a standard statement on this, which is that evolution of 368 is correlated to the evolution of the amenability of fundamental rights and the relationship between rights and directive principles. And this, of course, has evolved through a series of constitutional amendments and landmark Supreme Court judgments, of course, ultimately giving birth to the doctrine of basic structure, which set the course for activism and review. So, this is route 1, this is route 2. This affects Article 368, which then lays the foundation of basic structure, which could then have an impact on judicial review and judicial activism in its domain. So this is how you would sort of contextualize the evolution of 368. Now, what I'm what I've presented here before you is essentially a timeline of events that have happened. Now, please note the earlier cases when we talk about Shankari or Sajjan, or we talk about Madras and Kerala education. These cases essentially establish context. So you need to only know the broad details of it. The game really starts to change post Golaknath. Okay, and this is essentially how I could try my level best to make it fundamentally clear to all of you. So if I have to sort of give you a quick rundown as to how things have to be, so this is how it is, right? So when we talk about amenability of fundamental right, which is timeline 1, and we talk about relationships between rights and directive principles, this is timeline 2. It starts with a bunch of land reforms that the government did. There were obviously pushback and cases filed to those land reforms. The government enacted the first constitutional amendment within the first year of the constitution itself, wherein we added 31A and 31B. 31A basically said that if the government is acquiring land, then there is no fundamental right violation. And secondly, it added the ninth schedule and added those bunch of land reforms. And these, of course, would not be judicially reviewable, right? This was, of course, challenged in Shankari Prasad, in which the Supreme Court said constitutional amendments are not law under 13 clause 2. And by the way, this is still the case. Even today, constitutional amendments are not law. It's just that they're subject to basic structure. And second, the Supreme Court also said the Parliament can amend any part of the Constitution. Then a few years went by, the government added a few more land laws to to the ninth schedule under the 17th constitutional amendment, which then, of course, was challenged in the Sajjan Singh case in 1967, wherein, of course, the Supreme Court upheld Shankari Prasad's judgment. The fundamental difference between Shankari Prasad and Sajjan Singh was Sajjan Singh challenged the procedure through which Article 368 had to be executed, but the end product was, of course, the same, and that's something that we must keep into account. And then when Golaknath challenged the 17th Amendment, the First Amendment, and the Fourth Amendment also, that's when the Supreme Court did a complete reversal. It overruled all of its previous judgments and said, "Boss, constitutional amendments are very much under law as per 13 clause 2, and the Parliament can't make a law curtailing fundamental rights because there's no such thing as a constituent power." This, of course, was a massive hit back to the government. The government went on to a constitutional amendment spree, and the two most controversial ones at that time was the 24th and the 25th constitutional amendment. The 24th amendment is again directly overruling Golaknath's or superseding Golaknath's judgment, where the government essentially amended Article 13 and Article 368, wherein they essentially said the constitutional amendments are not law under 300 in the context of 13 clause 2, and the 25th amendment actually has an implication to directive principles, which we're going to come back in just a bit. To which, of course, the Kesavananda Bharati judgment happened, the largest bench ever sought out, and I'll give you the details of it in the next few slides. And the basic structure doctrine was conceptualized. Now, once the basic structure doctrine was conceptualized, and this is what you must understand, the fight towards government versus judiciary on what fundamental rights can be amended sort of came to a halt. And then the government started looking at the DPSP fundamental rights route to look at, parliamentary supremacy. So actually, your fundamental rights amenability gets a little bit of a halt here. And it's around this time that the national emergency was imposed, and it had several implications also. For example, the judges who had given a dissenting judgment, one of them was in line to become the Supreme Court Chief Justice, was not made one. And this is in the case on Ananda Bharti case. As a result, of course, they resigned in protest, and Justice A.N. Ray was made the Chief Justice of India, which, of course, set snowballed into a massive upsetting phenomena. And since then, we've had almost, a rule of sorts, but in the form of a convention, that the senior most judge of the Supreme Court is always going to become the Chief Justice of India. Then, in the emergency era, the government enacted the 42nd Constitutional Amendment 1976, which of course has far reaching implications, wherein they looked at the DPSP route. And I'm going to come to that when I come to just giving you a brief of how the relationship between rights and DPSPs worked. So the story here starts with Champakam and Madras's case. This is also India's first ever reservation case where communal orders were challenged. Here, the Supreme Court clearly said that the DPSPs are not supreme to fundamental rights. They are absolutely not supreme. And in fact, the fundamental rights will always override directive principles no matter what. In reference to the Kerala Education Bill 1957, here also the Supreme Court categorically and as clearly as they could say, they said that fundamental rights will always override directive principles in case of a conflict. And you may have heard of a doctrine called the Doctrine of Harmonious Construction. And this doctrine of harmonious construction essentially has its origin in the Kerala Higher Education Bill. Now, from here, it gets jumped up to Golaknath and the rest, where, of course, Golaknath had an implication because this meant that the fundamental rights was sacrosanct, and DPSPs also could not override fundamental rights, which further reinforced the judiciary stand. The 25th Amendment categorically was a pushback from the government, where they said two directive principles are under 39B and C, which is equal distribution of resources and prevention of concentration of wealth. If the government is doing anything to implement these two directive principles, and your only objections are 14, 19, and 31, then these objections will not hold valid, and there is not going to be any judicial review on this. In the 42nd Amendment, they got a little too confident and converted from just these two directive principles to all directive principles, which was further carried forward to the 44th Amendment, which still was a damage control amendment, where they said all DPSPs are important in 14, 19, and 31, but there's not going to, but judicial review will exist. And this 31 in the same amendment was then removed, which essentially gave property as a fundamental right status, was removed under the 44th constitutional amendment, right? And then, of course, Minerva Mills, which was this was the judiciary's last attempt, and this is sort of where the basic structure became almost infallible, is where 39B and C were declared to be two supervisory directive principles as opposed to 14 and 19, and as much as possible, they should be harmoniously constructed. And then IR Coelho sort of brought back Kesavananda in the picture, wherein we, of course, spoke about anything added to the ninth schedule even before 1973 would essentially also be judicially reviewable. See, the idea was everything that happened up until now was essentially on a prospective basis. We used an American doctrine called the Doctrine of Prospective Ruling, which is why none of the landowners, Shankri Prasad, Sajjan Singh, Golaknath, Kesananda, none of them actually got their land ever back. So this is a broad idea of how things ran. The purpose of me giving it to you here is, depending on the needs of the question, please feel free to draw this timeline in your answer sheets. It is going to give exceptional clarity to the exam hall and to the examiner as well, and that you understand the entire picture as a whole. It's incredibly important to remember this. Now we look at the text. Of course, when we look at the text, there are certain provisions that we must know, and these provisions are fairly simple. That Article 13, Clause 2 says no law can violate fundamental rights. I gave you the context of land inequalities to which land reform acts were made. These were made at the level of the state because land was the state subject, and of course, there was pushback from the landowners because their rights to hold property was fundamentally being violated as it was a fundamental right. The parliament enacted the First Amendment, and then most of these judgments actually start with landowners. I mean, if you think about it, Minerva Mills was the only judgment on this issue which did not come out of land ownership. This was a nationalization of a textile mill in Bangalore issue. And therefore, land reforms can be said to be the starting point of one of the most important features of the Constitution. I would recommend that you pause the video here, read this, make your notes out of it, and then move on. I will not take a lot of your time just reading text on the slide. Now, some key milestones, and remember, don't do this in any more detail. Shankri Prasad, Parliament enjoys absolute constituent power, can make any changes as they want to. And if you think about it, and if you compare, Shankri Prasad happened in 1951. Champakam Doraijan also happened in 1951. So on one hand, the Supreme Court is saying the Parliament can make any changes to fundamental rights, and on the other hand, they're saying fundamental rights are supreme to everything else in the Constitution. The Supreme Court was also trying to play a balancing act if you compare it on the timelines, because Champakam and Shankri Prasad essentially happened around the same timeline, right? Quickly followed by Sajjan Singh, which essentially had the exact same outcome. And then, of course, the 1967 Golaknath case. Now, you don't have to look at the ingredients of these amendments per se, and just go through a judicial timeline also, which is completely fine. Wherein Golaknath overruled Shankri Prasad and Sajjan Singh, it was a 11 judge bench. This was a 5 judge bench, and this was a 5 judge bench. So you always require an equal number of judges or higher to overrule a previous Supreme Court decision. This is also why Kesavananda Bharati becomes a 13 judge bench, which of course I'm going to discuss. A very interesting thing to note is that in Golaknath and Kesavananda, both of them were very narrow margin judgments. It was 6 is to 5 here, it was 7 is to 6 in Kesavananda Bharati. And I'm going to come to Kesavananda Bharati in just a bit, which means 6 out of the 11 judges were in favor of something, which is why the majority of the judgment is held to be true. I've covered the basics of Kesavananda Bharati, that constitutional amendments are under law and the parliament can't touch fundamental rights per se. That's essentially the key takeaways from Golaknath. Now, When we come to Kesavananda Bharati, and this is where things have to be now done in a little bit of detail. Now, this is something you should definitely quote in your answers. So, Kesavananda Bharati is an absolutely unique judgment in the history of international constitutional law. Now, why is it incredibly unique in the history of international constitutional law? First, because it is passed around anxious political circumstances around the advent of the emergency, right? Second, it caused a shift in the balance of the democratic power, wherein we sort of restricted the powers of the parliament to how much they could sort of amend the constitution. Third, by the sheer length of the judgment and the diversity of it, all of the 13 judges gave separate opinions, and that became an unheard of story as far as Indian judiciary was concerned. Usually, what used to happen was judges who broadly agreed on the same terms gave a common judgment, and judges who did not gave a dissenting judgment. But here, each of them had like a unique perspective to share, which therefore made it exceptionally long. 800 pages, 420,000 words long, 11 separate opinions which were technically issued. And the other two essentially did give minor paragraph opinions, which is why I've mentioned 13. And this is one of the fundamental issues with Kesavananda Bharati also, that when 11 out of 13 judges gave detailed opinions on something, you had to then give you a summary of the judgment so that people could understand what is it that the judgment really meant, which also then creates a lot of confusion on the basic structure doctrine. And of course, the most important contribution to Kesavananda Bharati is the basic structure doctrine. Of course, the government had a massive pushback and had basically passed three constitutional amendments, which were also challenged in the case of Nanda Bharti post the Golaknath judgment. So I'm going to give you the specific developments in case of Nanda Bharti. So when the 24th Amendment was challenged, which basically had nullified Golaknath's case, Kesavananda Bharti upheld this. It said, agreed amendments are not under law. As far as the 25th Amendment was concerned, that 39B and 39C are going to be superior than 14, 19, and 31. Again, Kesavananda Bharti said, fine, no problem, we agree with this. Of course, judicial review was then taken back into account. The 29th Amendment, which had added the two land reforms, one of which was the Land Reforms Act of Kerala, which was, of course, then also upheld as valid, said the government is well within their rights to do so. What Kesavananda Bharati specifically overruled was Golaknath said no fundamental right could be changed or nullified by the parliament. Kesavananda Bharati said nothing doing. The parliament has the powers to make changes to the constitution. Let them do so. In fact, any changes that happen to the ninth schedule prospectively also shall always hold to be true. So when Kesavananda Bharati gave such a blanket power to the parliament that listen, you know what, go ahead, make changes to the constitution the way you want to. The only thing is make sure you don't violate the doctrine of basic structure. And by the way, you can use doctrine of basic structure as a fantastic example in ethics also on teleological basis that what is fundamentally right is that the principle should not be violated as opposed to a deontological approach where you're duty bound to do something which is moral. And therefore, the doctrine of basic structure, which is essentially a German idea evolved during the Weimar regime, if I remember my facts correctly, would essentially be a set of principles. And, you know, seven out of these six judges had given their own versions, and we've had additions to basic structure through Supreme Court judgments only and only. And that, of course, are the broad repercussions of it. So, this is essentially the facts of it. Now, I'm going to come to the analysis once I'm done with Minerva Mills as well. So, what happens in Minerva Mills is that the government says, fine, I can't do this, but under 39B and C, I can do things for preventing concentration of wealth and equal distribution. And there was a textile mill in Bangalore which was nationalized in 1970s, and the government said it wasn't able to function on its own, so the owners actually challenged it in 1977. In addition to this, of course, the 42nd amendment was also challenged, which basically had added fundamental duties. This was upheld by the court. It had made directive principles superior to other parts of the constitution, again upheld by the court. Only judicial review was allowed. It added the words secular, socialist, integrity also to the preamble. The Supreme Court upheld it. It had amended 368, which said that no amendment, whatever it is, to the Constitution can be judicially reviewed. So Minerva Mills overruled and declared this particular amendment, this particular provision to be invalid. And the 42nd Amendment had also made changes saying that there'll be no limitation on the Parliament to amend the Constitution. Again, these were just amendments which were made to Articles 13 and 368 in context to Article 31. The analysis is, the conclusion here is, Minerva Mills is the last case. It's the last case wherein the Parliament tried to have an effect, and the Parliament tried to make a difference to sort of become parliamentarily supreme. To which the Supreme Court then said, "Boss, this is where we put a stop. This is where the bucks comes to a stop." And in fact, it is Minerva Mills which is marking the beginning of judicial supremacy, and the Supreme Court becomes the final arbitrator of constitutional interpretation. And what you can also write as a conclusion here is, it is as important as Kesavananda Bharti, because this was essentially a direct counteraction to Kesavananda Bharti and Golaknath. So this is the final nail in the coffin, and the story gets consolidated here itself. So it therefore then makes us question, what is it that is the case today? You can change anything you want to as long as it does not violate basic structure. The analysis is that we've seen more than 100 constitutional amendments. We've seen a higher expanse of judicial review. We've seen that the 99th Amendment has been struck down, where it is essentially a perverse application of judicial review, because the NJAG essentially created more accountability to how the judiciary was appointing itself. We've seen the 103rd Amendment. We're also now looking at the 104th and 5th. We've also seen Article 370, which is being currently challenged. We are seeing constitutionality of 35A, which is also being challenged because it essentially, the question is that, can you take away a status which was fundamentally guaranteed by the makers of the Constitution to a specific state? And all of this is going to largely revolve around basic structure and what is originally a text of the Constitution or not. So you could quote this as examples in your answers and sort of get done with it, and then look at the implications of Kesavananda Bharti and the emergency. Just in case you're writing it in an answer or emergency, or you're writing an answer on the implications or the impact of Kesavananda Bharti. First, as I said before, was the judges who dissented, who gave a judgment against the government, was sort of sidelined. One of them was not made the Chief Justice. In 1975, right, and this is a direct application of Kesavananda Bharti. In emergency, you would know that Indira Gandhi's candidature was declared invalid by the Allahabad High Court in the Raj Narayan case, and Indira Gandhi went on appeal to the Supreme Court, got a stay on the order on the condition. The Supreme Court said, "Fine, I'm staying Allahabad High Court's order only on the condition that you're not going to speak and vote in the Parliament. You're just going to continue discharging your duties as the Prime Minister." She accepted the court order. She had no option to, of course, and then passed the 39th Amendment of 1975, which was actually challenged in the Supreme Court, wherein the Supreme Court said, "Boss, free and fair elections and rule of law is basic structure. You have allegedly misused government machinery, and therefore we are going to hold you accountable for it. And we can't make any law that gives you an upper edge over other people who get elected. So it's a violation of free and fair elections." The Supreme Court did strike down 39th Amendment, but only did so prospectively, which means 39th Amendment application to prior elections was still valid, which is why she got away without a whisker. The same judge who was appointed the Chief Justice in 1975, Justice A. N. Ray actually set up a 13 bench in 1975 to review Kesavananda Bharti, hoping that you could overturn a lot of it. But for reasons unknown to any book, any author in the country, this 13 bench was dissolved within 2 days. The reason we have very little information about this is because this is around the time the emergency was imposed and the press was not allowed to report on court judgments. And because the press was not allowed to report on court judgments, the press could not essentially explain to us as to why this happened and why it did not happen. All right, so that's that. Now, when we look at a broad critical review of the basic structure doctrine, it's again very simple. There are some good things about it, there are some concerns about it. First, the one thing was exceptionally clear that the Supreme Court became the unmatched authority when it came to constitutional matters. Second, it established concretized judicial review forever. Third, we must understand through the components of Kesavananda Bharati's case it was not an anti-government judgment. The parliament could still make anything it wanted to as a change to the constitution. Constitutional amendments were still not law. Directive principles were still moderately, specifically, and to a few superior to a select few fundamental rights, and so on and so forth. So, of course, it was still a sort of a balanced judgment. And something, the 20% principle that I talked to you about, this is something that most books don't talk to you about. So judgments given by one country are not binding on other countries, but other countries are often taking note of the judicial developments. Like for example, the Supreme Court's judgment on the Vodafone case was how Vodafone won in the South African Supreme Court. The Supreme Court of South Africa took into account the legal rationale adopted by the Indian Supreme Court, which is essentially what has happened here as well. So the Kesananda Bharati had was readily accepted by the apex courts of several South Asian countries. And for many, many years, any military coup, any attempts of any non-state actor or the military to overthrow the government were fundamentally prevented because of the doctrine of basic structure, which had some persuasive value in and around. Of course, there are some three fundamental concerns with the basic structure doctrine, and those three fundamental concerns are: first, it is an idea, it's a policy kind of a thing. Nowhere, not a single provision in the Constitution of India mentions or even so much as references to basic structure, which means it is in thin air. And because it's in thin air, you can't make a change to the constitution to change basic structure. Two, it's exceptionally lengthy, which means what exactly does it mean is still a matter of subjective debate. And third, because it was such a close call of 7-3, there is still no sort of harmony on the actual implications and what it actually means as basic structure. Right. So therefore, there is an analysis of the basic structure doctrine, which is a simple one. And if you have to, if the mains exam will ask you was it right or wrong, you would say at gunpoint, if I have to choose between the legislature and the judiciary as the custodian of the constitution, I would most likely choose the latter, because the judicial supremacy is because of parliamentary incompetency. At the same time, let's also understand it sort of lays the ground for activism and other entrenchments made by the court, which means the traditional notions of judicial review, wherein you review laws which are actually made. You strike the laws down, it makes sense. But you come up with something which has no mention in any law is actually not judicial review. It is judicial activism, right? And it is a matter of unquestionable understanding that this essentially was seen as and was taken into account as what is called a rescue operation of the judiciary by the judiciary of the Indian democracy. And if even had to overrule basic structure, you would require minimum 13 judges, which is slightly difficult. And because it does not get specific mention, it cannot be overruled by a law. It cannot be overruled by a constitutional amendment, because the amendment will have to say XYZ article will now mean ABC. But there is no XYZ, so how will there be an ABC? Which means the only way you're going to do this is through extra constitutional methods, certain executive actions here or there, which again the judiciary will strike down as violation of basic structure, right? And that is it. Now, the larger question is this justified? And this becomes your final conclusion. Yes, because constitutionalism means limiting the powers of the state. So if you give parliament uncontrollable powers, then it becomes a non-constitutionalist parliament. And that's not what we set out to be. So therefore, it would defeat the purpose of having a constitution in the first place. And then we've got the history to back us up, which basically means the government has been known to enact certain constitutional amendments, which no doubt have been very questionable throughout legal history. And one must not forget the famous adage that absolute power corrupts absolutely. Now, this does not mean the Supreme Court rides a high horse and starts ravaging the parliament at any moment that it gets. It should also respect the democratic mandate, because at the end of the day, they are the parliament, they're the government. That's because the people have entrusted them with, with their votes, and therefore a collective morality must exist in the interest of the people. So this is it. This is how you would write an answer on any possible question that could come under 368. So I've given you all the ramifications of it. I've given you attached handouts on the relationship of directive principles and fundamental rights. I've given you a broad timeline explanation of this. I've also given you a broad review of fundamental duties and the preamble in the handouts. I'm going to now pick up specific issues pertaining to, say, media and censorship and all of those things in the next series of the playlist. So you can watch the next video after this. Thank you for for watching. Thank you for your time. And most importantly, thank you for your patience. See you.